Is there any way that we can ask facilities people to lower the temperature for us a little bit?
No, because this room cannot be adjusted.
This cannot be adjusted. But it's a little bit too hot, isn't it?
Maybe we can change this room to another classroom, and other classrooms can be adjusted.
Are better?
Yeah.
Do you feel hot or not?
No.
Okay, we'll stay. All right, let's continue. 2 more cases, okay? And then for today. It's the Shinitsu case, Indian Supreme Court, 2005. And then the first option case, U.S. Supreme Court, 1995. So, your textbook author liked the dissenting opinion better than the majority opinion. That's why he reproduced the dissent. It's a lengthy opinion and very well written. Covers all the important parts. Let's try to go over that one. And he outlines the question for us on page 223 at the very bottom. And he says the real question for consideration is as to the nature of adjudication that is contemplated by section 45 when the objection about the agreement being null and void, inoperative or incapable of being performed. Section 45 is Indian law that actually incorporated the New York Convention verbatim, as it is, exactly. That's what it says. So the question in this case is the nature of adjudication. That's what we've been talking about earlier. The court obviously decided, and if you keep reading, should the judicial authority, while exercising power under section 45, decide the objection or a prima facie view of the matter and render a prima facie finding or a final finding on merits on affording parties such opportunity as just the case may demand, having regard to facts of the case. The question is important and at the same time not free of difficulty. World over, opinion is divided. That's how it starts it. Some courts have preferred prima facie review, others have preferred a final adjudication on the merits. That's what we do. Because the guidance that we have from the New York Convention is incomplete. So courts have to supplement it. So, what was the court's decision based on the dissenting opinion? What's your understanding of what the court has endured? The court, what have they said?
The dissenting think that we should take the traditional way, that is, the review should be final, not regulation.
Did the court make that decision? That's your understanding of it?
No, it's
the dissent. Now, tell me whether he makes his case very well. Are you convinced of his analysis? And what is the strongest argument that he makes to arrive at this conclusion? conclusion?
Save cost and time.
Save cost and time. So let's just get it over with. Why do we bifurcate jurisdiction? Why do we send it to some other people and then look over again? Instead of doing that, why don't we just make a final decision on the validity of this thing when it first comes to court? So that is a policy decision, right? On the basis of the economy of time and resources. But he also makes a text-based textual argument. What is that argument? Does he think that there is ambiguity in the law? He doesn't. What does he say?
The term shall in its ordinary significance is mandatory. So the word shall and unless appear in the section 45 mandate that before referring a case to arbitration, the judicial authority should be satisfied that the arbitration agreement is not null and void. So the court should review them. It's the judicial authority that they have that such authority to determine it, and they have such discretion to determine it.
That's exactly the key passage in this whole opinion, where it says, it's in the middle of 225, the authority should be satisfied that the arbitration agreement is not null and void. See? The judicial authority must be satisfied that it is not null and void. So there is no ambiguity when the law says unless it finds. It finds means unless it is satisfied that it is null and void. So for him, we're creating ambiguity when it doesn't exist. Where is the ambiguity when it says unless it finds? It finds means it needs to be satisfied, right? If you interpret it that way, there's no ambiguity. And to satisfy yourself, you need to do whatever is required of you to do. And he supports it by a policy argument by saying it makes sense. Because if we just deal with it from the very inception and court that makes a decision, then we will be able to avoid waste of time and resources down the road. Now, is that a convincing argument? First of all, does a more thorough review of the validity preclude the possibility of future review? The economic argument, the efficiency argument. Does it? If you get a decision from the court that says, we are satisfied that the arbitration agreement is invalid, what do you expect to happen? So the court fails to refer the matter to arbitration, right? What if the court says, yes, we are satisfied that the arbitration agreement is invalid and therefore is valid, and therefore we refer it to arbitration? Is that the end of the inquiry? So that means the case goes to arbitration, and then whoever doesn't like the award is going to come back and say, oh, the abstract tribunal didn't have jurisdiction in the first place. It could be somewhere else, right? Another jurisdiction. But if you bring it back to the same court, that decision had already been made, Therefore, in that sense, there is some efficiency in this approach. But it does not preclude the possibility that the same thing may be relitigated somewhere at some point at the end of the process. So the efficiency, the economy argument may be valid in some sense, but it may not be valid in some other sense. But does he make the decision that there needs to be a full-fledged determination of the merits of the validity of the arbitration agreement? Or it is somewhere between a prima facie review and a full-fledged hearing? You noticed what he was trying to say?
Within a fixed time frame, and they don't really look at the really review merit issue as the evidence, like the cause of these things. So I think they just look at it in the middle.
Yes, I think it's a middle ground approach. That's absolutely right. He tries to put a time limit, and he also restricts the nature of evidence that needs to be presented. He limits it to what?
2 months.
Huh?
2 months.
Yeah, the time, yes. But the actual evidence that need be presented is also limited.
Without oral evidence, the evidence must be written.
Evidence is limited to?
Written document.
Exactly. Affidavits, written documents. So you adjudicate the validity of the arbitration agreement on the basis of affidavits from the parties. You don't hear oral testimony from witnesses. And then you need to do it within like 3 months or so, until you satisfy yourself that the arbitration agreement is valid or not valid. So it's a middle ground approach. It's not complete. It's not like this. We'll talk about this. It's not like this. No, it's, yeah. And it's somewhere between these two. Do some extensive factual inquiry. Try to understand whether this thing is valid or not. Get affidavits, and then make that decision. But I don't allow you to hear witnesses, engage in fact-finding of other types. Do some due diligence on this arbitration agreement before you decide to enforce it or to refuse to enforce it. So that's how he differs from the majority opinion, where they say, oh, we only do a prima facie review for manifestly null or whatever standard they say, and then refer to arbitrators and let the arbitrators worry about the actual decision on the merit stuff, the arbitration. Now, the other dissenting justice differs from this one in a number of different ways, and cites to numerous precedents. The French approach prima facie, the Swiss approach null and void is prima facie, and there is the Hong Kong approach. It's on 229. 229. In the middle of that, there is indented model, indented text. The court at the High Court of Hong Kong observed that if I am satisfied there is a plainly arguable case to support the proposition, and there was an arbitration agreement which complies with Article 7 of the model law, I should proceed to appoint the arbitrator in the full knowledge that the defendants would not be precluded from raising the point before the arbitrator, and having the matter reconsidered by the court consequent upon that preliminary ruling. Apparently, that's the law in Hong Kong. So what is it? Is it the prima facie kind of approach? Manifestly null approach? Or some other type? Or is it the dissenting opinions approach whereby you conduct a limited review with affidavits and limited time? What is the judge of the High Court of Hong Kong saying in this particular passage? What is the standard? Plainly arguable, right? That's what it says. Plainly arguable case. Plainly arguable case. Some appearance, some type of evidence. It's more or less a prima facie. On its face, does it seem like the two parties have some kind of arbitration agreement between them? The plainly arguable standard may be made by the presentation of a signed document that actually looks like the other party has also signed it. What if that party appears before this judge and tells the High Court, Your Honor, I never signed that agreement. That is not my signature. Under the plainly arguable standard, may that court refer the matter to arbitration, or must it take its time to determine whether that signature is not forged or not, is or is not forged? You have two competing factual allegations. One says, he signed it in front of my eyes. Why is he denying it? It's this guy who comes, I never did. Prove it.
Go to the arbitration. Because it's arguable.
It's arguable, right? Go to arbitration and let the arbitrators worry about it. It seems like maybe the judge asks a few more questions. Does it look like your signature? Sign and show me. If it looks like it, oh, maybe you did sign it. Let the arbitrators determine the final outcome on that. I don't know. Maybe that's what you would do. What would you do if you are the judge? Two competing testimonies. One says, absolutely, he signed it in front of my eyes. The other guy says, no, this is forged. He forged my signature. I never signed it. The only way that you can find out the truth is by actually presentation of more evidence, right? In this case, there is the he said, she said. Is that enough to say it's plainly arguable, therefore go to arbitration, let them find out? Probably. Probably. If you follow the affidavits approach, you might ask them, okay, bring some more affidavits from some other people. I don't believe any one of you. Bring me some more evidence. One gives you an affidavit, the other doesn't. And then, oh, yeah, this guy has two, himself and this additional evidence. This guy does not. Preponderance of the evidence. Go to arbitration. And then, when they appear before the arbitrators, the same issue is going to be raised again, right? That guy's not going to go away. He's going to say, I never signed it. At which point, he would be required to present the evidence. Or the other side would be also presenting evidence. Do you think those kinds of disputes are impossible in real life? People actually denying things? It happens. It happens all the time. Not necessarily because they are actually lying. It could be because of many complex things. These guys might have done business 100 times before. and they signed 80 different documents. One remembers it like he specifically signed that document. The other one says, no, I never did. So it could be lapse of memory, all sorts of problems. Sometimes it could just plainly be one is actually not telling the truth. The only way you find out is through the presentation of more evidence. So, you follow these standards, the outcomes could be different, right? And of course, the last justice in this case talks about forgery, requiring a full-fledged trial, and he takes this middle ground approach is nonsensical. You either do it or you don't do it. Makes no sense. You do affidavits, you say it's 3 months, another time you say it's 6 months. It's not manageable, it's not administrable. You may as well conduct a full-fledged hearing or just say on its face, it looks okay, refer it to the affidavit. So it doesn't seem to like the prima facie, the middle ground approach. Okay, most important of all is the first option test. It is cited in so many arbitral awards and arbitral court judgments and whatnot. We need to understand it, and it's still valid law in the United States. And cited by many courts outside the United States. Let's go over the case slowly. What was and how, this is an example of this approach, right? That is this is a back-end review of the validity of the arbitration. So, what was the objection by the Kaplans about the validity of the arbitration agreement and hence the jurisdiction of the arbitral tribunal? What is their objection? Why is the arbitration agreement now valid?
Because they did sign the arbitration agreement individually.
Exactly. That's what they say. They never signed it. They denied signing the arbitration agreement. They weren't a part of it. They weren't a part of it. And what was the main question in this case? One party says that yes, there was an arbitration agreement. The other party says no, there was no arbitration agreement. But the main question was it that whether or not there was an arbitration agreement or something else? Of what?
Of the award.
Yes, but of course the arbitration award would require you to review whether there was jurisdiction in the first place or not. So what was the fundamental question that the court was addressing in this case? Exactly. It's the who question. Right? It was the who question. Once you answer the who question, of course they would address the standard of review, and they identify a very good one for us. So they say, who, court or arbitrator, has the primary authority to decide whether a party has agreed to arbitrate, can make a crucial difference to a party resisting arbitration. And it says in the middle of that page 231, we believe the answer to who question is fairly simple. They say it's simple, right? Why is that simple? Huh?
Parties intention.
That's why they say it's simple. It's simple. It depends on did the parties really intend the court to decide it or the arbitrators to decide it. So it's all about the parties' intent. Just like any contract. Did they agree? Now, they frame the questions very well, very helpful to their reading. The question, the standard of review applied to an arbitrator's decision about arbitrability is a narrow one. To understand just how narrow, consider three types of disagreement present in this case. There are three disagreements, right? Number one, the couples in first option disagree about whether the couples are personally liable for NKI's plea to first option. That is disagreement on the merits, right? That's the contractual dispute. Second, they disagree about whether they agreed to arbitrate the merits. That's also fairly simple. Whether they have an arbitration agreement to arbitrate the merits about the first question. Third, they disagree about who should have the primary power to decide the second matter, which is the who question. And then it goes on saying the who question is fairly simple because it depends on whether or not they agree. But they disagreed about their agreement. Right? And it is very simple. It's a question of evidence, not of law. If the law standard is very clear. Now the problem, the whole problem of the who problem is because you have two possible decision makers, potentially, the court or the arbitral tribunal. And to make matters a little bit more complicated, there is a little bit of hierarchy between them. Because the court always has that primary responsibility, whether it comes at the front end or the back end. Just to be very clear, there is that leverage that the court has. The court, the tribunal's jurisdiction, the extent of the tribunal's jurisdiction is just about how much the court is willing to give it. And of course, the court's power itself is not constrained because it's constrained by what? By law. So it is actually interpreting that particular law to make the appropriate allocation of competence between itself and the arbitral tribunal. But here they simplify it for us. We believe the answer to the who question, i.e. the standard of review question, is fairly simple. Just as the arbitrability of the merits of a dispute depends upon whether the parties agree to arbitrate that dispute, citing to some authority. So the question who has the primary power to decide arbitrability turns upon what the parties agree about that matter. Did the parties agree to submit the arbitrability question itself to arbitration? That is the key question. Did they or did they not? So they actually simplify it for us. But the problem is this. Now the French Court of Cassation was perfectly aware of this particular formulation, perfectly aware of this analysis. Framing the issue is simpler than coming up with the answer to that question. Right? The question of who is simple because it's a matter of intent. That's what the Supreme Court is saying. But now we have another problem, right? How do we know if they agreed? One is saying yes, they did. The other one is saying no, they did not. Who should determine whether they did or they did not? And how closely should that person or entity be looking at this particular question? Do you do a prima facie review for nullity, manifest nullity, or do you do something else? So what is the standard of proof that the court must apply before it decides to refer it or refrain from doing so? The court articulates a very clear standard for us, right? What does it say? What is the standard that comes out of, the most important standard that comes out of first option? So objective, what else? How do you assess the intent of the parties? What is the standard? Huh? What is it? What is the specific phraseology they use? Yeah, but they say something else in terms of articulating the standard. Clear and unmistakable. Exactly, that's what they say. Clear and unmistakable evidence. Unless the court finds that there is clear and unmistakable evidence that they actually agreed to assign the responsibility of assigning that responsibility to the arbitral tribunal. In other words, unless there is clear and unmistakable evidence that they agreed to arbitrate arbitrability, then the court must adjudicate the controversy. That means there is no arbitration agreement. It's a higher standard than this, a higher standard than this, a higher standard than all of these combined. In other words, the court needs to determine whether or not there is clear and unmistakable evidence that the parties have agreed to assign the question of arbitrability to the arbitral tribunal. In other words, that they wanted the arbitral tribunal to decide the validity of the arbitration agreement itself. That it's been made, that's not void, that is not vitiated with other types of defects. So if you look at page 232, the second full paragraph, this court, however, has as we have just said, added an important qualification applicable when courts decide whether the party has agreed that the arbitrator should decide arbitrability. Courts could not assume that the parties agreed to arbitrate arbitrability unless there is clear and unmistakable evidence that they did so. That is the most important passage in this whole case. You cannot assume. It is exactly the opposite of this manifestly known. So what we have is standards ranging from manifestly known to clear and unmistakable evidence. So when the Supreme Court of India says opinions around the world are divided, he is right. this is a range between those two extreme positions. And he tried to strike a balance between the two and say maybe non-clear and unmistakable evidence, do some affidavit type trial within a limited number of days, see if we are convinced, we are satisfied that there is a valid arbitration agreement. And then you have the French approach that says, look at it, and if it seems like there is an agreement, send it to the arbitrators and let them worry about it. And then there is the U.S. Supreme Court approach, which says, listen, arbitration means you are giving up your judicial remedy. We cannot take it very casually. We must determine that they have actually decided that arbitrators should decide whether they have an agreement or not. Take a look at it very closely. Now, which approach makes more sense? And in terms of the economy of things, in terms of the expectations of the parties, and judicial propriety, enforceability, and things like that. Which approach do you think is a better one?
I think when we talk about parties' autonomy, I think the French court's decision is more better because it assumes that party want to go to arbitrator, and arbitrators should have such an authority to determine whether this agreement is valid. They should have this authority. But when we talk about the enforcement, I think the first options, the American court is better because if you want to enforce the award of the arbitrator, you should also seek the help of the court. So maybe the court decide this first, they will more efficiency, I think.
Okay, so yeah, if this is the standard, the possibility that when it comes back to the court that it would be approved is higher, right? Mm-hmm. Because they had already determined its validity. But if they only took a very casual look and manifestly no, the possibility that at the very end of the process, the court might say, no, it's not valid, is higher. So in that sense, it is I think it's economical to do it in the first place. But from a party autonomy point of view, the manifestly no would send more cases to arbitration, right? And assuming that the parties have some type of agreement, and then in reality, in the absence of an arbitration agreement, the chances of somebody saying that, oh yeah, we've agreed to arbitrate with a stranger that he doesn't even know, those possibilities in real life tend to be very low, right? It's usually between parties who've known each other, who've done business before, who've had some arbitration clause, and sometimes it doesn't. So if it appears that they've done that before, and there's this particular one, and particularly when it is signed between businesses and between equals, this might actually work. But in the consumer type agreements, where there is this imbalance between negotiating powers. One is a big company that actually gives you, sign it or just leave it. And the other one is just a consumer that just has to sign things. In those instances, it might be better to have a very exacting scrutiny about whether or not there was a valid agreement to give that jurisdiction to the arbitral tribunal rather than the courts. But in any case, you just have to look at the standard that applies in the jurisdiction that you're operating. That's one of the things about this an arbitration world where The laws are not the same, the standards are not the same, it's just the principles that are the same. The principle of competence. Competence is everywhere. But when you dig deeper, what does it mean? Then you find all these differences. So on its face, the principle of competence, all it means is that the tribunal does have the competence to decide competence. Its own jurisdiction. But by the time it gets to the tribunal, a lot of things have happened in the court system. They have looked at the agreement in one way or another, and now it's before the tribunal. The tribunal all of a sudden asks to answer the same question that the court had answered before it. So when that happens, the tribunal is confronted with two possibilities. One is to agree with the court's prior decision, which is that yes, it has the jurisdiction. The other possibility is to disagree with the court's decision. I was asked last class, in the last class, what happens if that's the case? Which is, the tribunal, the court said the tribunal has jurisdiction and send it to the tribunal for it to determine its own jurisdiction, competence. What if the tribunal actually disagrees with the court and says, I don't have jurisdiction? Now, the New York Convention does not say and cannot say that the tribunal refers the case back to the court. It just ends there. This guy is without remedy. No arbitration, no court litigation. But not necessarily, because when the tribunal refers the matter to arbitration, it recognizes the principle of competence, and if the tribunal actually says, no, I don't have the jurisdiction, that means the court will retain jurisdiction and adjudicate. That would be the most logical outcome. All right, briefly, 4 cases today. Is the Zurich ambiguity case and public order. It's basically the manifestly null or prima facie kind of approach. There's the French court causation, now manifestly null standard they articulated in the Renault case. And then, of course, the Shinizu nuanced middle ground Supreme Court of India. We've looked at that. And then the extreme end would be the first option. So that is the range right here between very differential review to exactly. The principle of competence, who decides. There you go, in its entirety. Next class, we'll take a look at one more case, basically bringing all of these things together in a more nuanced way. This is the UK Supreme Court, and then we'll talk about the applicable law, how it's selected, how it's applied, like of course as well as the arbitral tribunals. Okay. So unless you have any questions, we can end it here for today, and then reconvene on Sunday at 10 a.m. I think that's the schedule for us. So we'll reconvene. Okay.